My name is Keith Vance. I am a personal injury trial lawyer. I've been helping those that have been harmed through no fault of their own for over 27 years. And today I'd like to talk to you about litigation. Now, if we can't settle your case in the pre-litigation phase, then we have to move into the litigation phase. And that's where we file a lawsuit and we prepare to go to trial. At trial, a judge would preside over the case and a jury would decide all the issues, including your damages. So let's start at the beginning of litigation. Litigation starts by us filing a complaint, which is a legal document that sets forth the facts of the case, as we believe them to be, the theories of relief, the legal theories, and what we want or demand for compensation. Not a number, but it sets out the categories and exactly what we're looking for from the jury. Once the complaint is filed with the court, and we file that in the proper venue, in the proper jurisdiction, we will serve it on the other side. We have to serve it on the person that's responsible, the person we're suing, in your case, with the process server. And they'll hand them a copy of the complaint, and they will be they'll be expected to file a response, an answer to the complaint within a short time. Then we go before the court, and we develop what's called a case management order. Now, a case management plan, that's another phase of your case. After the complaint's filed, after it's been served on the other side, they'll hire an attorney, or an attorney will be appointed to them by their insurance company, and we move forward into developing a plan for the litigation, which is a case management plan. We meet with the judge to do that. Once we've done that, usually a trial has been set. It'll be set down the road, several months. It allows us enough time to get ready for trial. Because after the case management plan, we move into what's called the discovery phase of litigation. Discovery is just what it sounds like. We're trying to discover what the other side has in the way of evidence, what their theories are, what their defenses are in your case. We'll be taking depositions. We'll be sending out interrogatories, which are written questions the other side has to answer. We will be doing our own investigation. We'll be hiring experts to prepare to help the jury understand your medical issues and the liability issues, if that's part of the case, and maybe why we think the other side is wrong and we're right and therefore entitled to justice. Discovery. It goes all the way until about 49 days before trial. During the discovery phase, we're going to move into what's called the mediation phase, which every court in Colorado requires mediation, alternative dispute resolution, a settlement conference. They're all the same thing. We go before usually a retired judge or maybe a retired lawyer who's done this kind of work quite a bit, and we ask them to help us kind of go between the two sides and mediate the case. That's an opportunity to settle the case. It's the best opportunity you're going to get to settle the case before trial after a lawsuit has been filed. Usually the insurance companies get pretty serious about settling the case at mediation because by this point they've seen what the case is all about. They've seen the discovery on our side. They've taken your deposition. They've sent you interrogatories. They've demanded production of different documents, and we've complied with that. They've seen our experts. They know what they're going to testify to at trial generally. And at mediation, they can avoid a trial where a jury decides your fate by offering a good amount of money. If they offer a good amount of money, full justice in a case. I talked about full justice in the other video. I compared it to justice, like if this coffee cup were justice, it needs to be full. We're not going to accept half justice, because that's no justice at all. And we don't want to run it over, but we want full justice at the top. If they offer full justice at the mediation, we will recommend that you accept it because that wouldn't be any better than what you might get at trial. But if they don't, and sometimes they don't, we will prepare and go to trial. Now, trial is a several-day event, 3 to 7 days typically, depending on the complexity of the case. We will go to trial on your behalf. And trials are battle. Trials are intense. You got to be on your toes. You got to be sharp, and you got to be experienced. You don't want a settlement lawyer if you're going to trial. You want a trial lawyer, one that's done this a lot of times. We've done this a lot of times. We've gone to a lot of trials. I've personally tried over 50 civil cases for money, personal injury cases. I've tried a bunch more criminal cases. But you need an experienced trial lawyer, one that's seen battle, one that has combat experience and can navigate through the maze of a trial without stepping on some landmines. We will do that for you. We'll take it all the way. Now, trial leaves the decision in a case like this, your fate, in the hands of a jury. 6 people that you don't know, 6 people from the community that may or may not get it right. We'll do our best to help them see the light. We'll shine light on the truth. We'll shine light on the important facts of the case and help them hopefully get things correct so that they award full justice in your case. Once the verdict comes down, we're at post-trial. The insurance company doesn't pay immediately after trial. Even if the jury has spoken and we know what your case is worth according to the jury, the insurance company may want to file motions, they may want to appeal, and we're going to do some stuff on our own. We're going to get the case amended for the jury verdict, amended to include interest. You're entitled to interest on the judgment from the day that the injury event occurred. If we're the prevailing party, meaning if we win the case, we'll also get our costs paid for. We'll get the judge to include that and amend the judgment to include costs and interest, which raises the amount that the insurance company would have to pay. And a lot of times the insurance company throws in the towel and they pay. Sometimes they file an appeal and we have to go through the appellate process before you ever get paid. We may even have to try the case again. Trials are costly, but they're sometimes the only place you can get full justice. I hope this has been helpful. We will answer any questions you have. As they come up along the way, call us. We are very hands-on. We want you to be informed, we want you to understand, and we want you to be happy. So call us. Thanks for listening.